requested you to give a lecture. Advocate, I know I can always count on you. If there's something that needs to be done, I come to you to do it. And we both realize that this year is the 50th anniversary of the Apartheid Convention, as well as the 75th anniversary of the adoption of the Universal Declaration of Human Rights. So I just couldn't think of a better person to give a lecture on this topic, Advocate. As it happens, South Africa has, even though this International Day was named after an event that took place in South Africa, but we have not been at the forefront, of global discussions, about racism, about racial discrimination. And so, in a sense, this event today is our coming out event, Advocate. And I just want to thank all of the colleagues who are here. I know it's a public holiday and you guys are taking your time to listen to the Advocate. And so what Advocate Thembeka Ngqwaito will do, will speak for about 45 minutes or so. Advocate, 45 minutes, maybe to an hour, and then we'll have a conversation after that. I presume we know our guest speaker today is a public intellectual, he is a well-known lawyer, senior counsel. He's also an author of 2 wonderful books. And so we are privileged to have you this afternoon, Advocate. So the floor is yours.
Thank you, Dr. Molunga. I appreciate you saying that you couldn't have thought of a better person, but at the same time admitting that you invited me very late when you had run out of options.
No, no. I can always count on my friends.
So that just shows me precisely where I fit in the scheme of things. Thank you for the invitation. I'm very privileged to be here. My topic is entitled, my paper rather, is entitled, Is Apartheid the Forgotten Crime Against Humanity? Let me begin on the 30th of November, 1973, exactly 50 years ago. That is when the United Nations General Assembly passed probably one of its most important resolutions when it adopted the Convention on Apartheid. In the opening paragraph of that convention, it is declared that apartheid is a crime against humanity. According to the convention, the crime against humanity is because of the inhumane acts resulting from the policies and practices of apartheid, which violate international law, the Charter of the United Nations, and thus constitutes a threat to international peace and security. But it goes further. It holds the organizations, institutions, and individuals responsible for the design and enforcement of apartheid as criminally culpable. So from inception, the United Nations Charter of 1945 had set itself against racial discrimination and the domination of one race by another. But until the Convention on Apartheid was passed in 1973, the world had largely tolerated South Africa's obnoxious policy of apartheid, and it had occupied itself with world peace, the decolonization of Africa and Asia, and the reconstruction of Western Europe after the Second World War. But after 1973, the focus of the world turned to South Africa in the pursuit of the commitments of the Charter of the United Nations. The system of apartheid, founded as it was on racial supremacy, was incompatible with the principles of the Charter. But for the first time, it now also constituted a crime in international law. So what was the significance of declaring apartheid as a crime in international law? In a departure from the standard understanding of a crime as an act in violation of a law committed by an individual, apartheid was recognized as a systematic crime a crime not committed by an individual against the state, but committed by the state itself against its people. We see this clearly from Article 2 of the Convention, which specifies the elements of the crime of apartheid. These inhumane acts were committed to establish and maintain racial domination and a systematic oppression of people. And this was the essence of the crime of apartheid. In other words, it was not isolated individual acts, but the system as a whole that was the hallmark of apartheid. The elements were, firstly, as set out in the convention, the deliberate imposition on a racial group of living conditions calculated to cause its physical destruction in whole or in part. Secondly, laws calculated to prevent a racial group from participating in the political, social, economic, and cultural life of the country. Thirdly, the deliberate creation of conditions preventing the full development of a racial group by denying them freedoms such as education, nationality, freedom of movement. Fourth, the separation of reserves and ghettos on racial grounds. Fifthly, the expropriation of land and property belonging to a racial group or groups or to members thereof. And sixthly, the exploitation of labor of the members of a racial group, in particular by submitting them to forced labor. And so when one looks at these elements, the convention then captures the essence of apartheid in three respects. Firstly, it shifts the locus of accountability from the individual to the state. It recognizes that apartheid is, by design, systematic. In other words, it's not isolated acts of individuals driven by racial hatred. And finally, as a systematic crime, culpability for apartheid cannot only extend to isolated, identified individuals, because its benefits are widened. They include systematic economic advantage arising from the system. Dr. Hendrik Verwoerd, who was a key proponent of the apartheid system, once described it as a policy of good neighborliness. Another euphemistic term for apartheid was that it was about separate development. But the 1973 declaration exposed the facade of separate development. It showed that apartheid was the expropriation of land of Africans. It was the exploitation of their labor, and it was the deprivation of their fundamental rights and freedoms. And the declaration also showed that there were no different races, each developing separately and alongside each other. But what it did show was that the development of the white race as a whole was achieved at the expense of the black races. And no, apartheid was not necessarily founded on racial hatred, but it was racial supremacy that was its telos, its organizing principle. And according to the convention, blacks lived alongside whites, but they lived in a relationship of subordination. And when Africans were stripped of their South African citizenship, the effect was not to separate them from whites, but it was to sustain their position of perpetual subordination. But the convention exposed these facts to a global audience. There was also a moral imperative to the convention. The United Nations was founded in 1945, and according to its charter, it would promote and encourage respect for human rights and for fundamental freedoms without distinction to race, sex, language, and religion. And the Universal Declaration of Human Rights, which was adopted in December 1948 and turns 75 this year, was to the same effect. 1948 is the same year that apartheid became official policy of the white minority government in South Africa. which shows that while the world was universalizing the respect of human rights, rejecting racism and discrimination, here in South Africa, the government, the white government, was turning its back on the world, rightly earning the label of being the skunk of the world. The International Covenant on Civil and Political Rights, which was adopted in 1966, was also based on the principle of the extension of human rights to all without regard to race. Immorality of the apartheid system aside, there was also a legal imperative. Some 30 years earlier, the Holocaust in Adolf Hitler's Germany against Jews had been declared a crime against humanity. What did this declaration mean in the context of Germany? From this declaration, victor's justice, as exemplified by the trials of Nuremberg, followed. Hitler's policies were condemned at Nuremberg. Some precepts of the rule of law were observed during the trials of Nuremberg, and people were not gassed or shot in the back, but they were subjected to public trials, as opposed to what Hitler had done in Germany. They defended themselves and they were duly sentenced. And Article 5 of the Convention on Apartheid also envisaged this type of justice because apartheid was a crime against humanity. It specifically said that persons charged for committing crimes of apartheid could be tried by a competent tribunal or by an internal penal tribunal. And upon conviction, criminal sanctions would ensue. In 1947, some 2 years after the Second World War, the United States passed military law military law number 59. Its purpose was to restore identifiable property that had been seized on racial, political, and religious grounds. According to this law, those who lost property during the German Holocaust were entitled to restitution. In May 1948, while D.F. Malan was in an ascendancy in South Africa, the state of Israel was being born. 3 years later, in 1951, the first chancellor of the Republic of Germany, Konrad Adenauer, would deliver a landmark address explaining Germany's attitude towards Jews. He noted the terrible crimes of a past epoch, and he observed that Germany recognized that everyone was equal before the law. Many bigots, of course, could have said this, but what was important for Adenauer were the practical steps to fulfill these commitments. He noted that there was immeasurable suffering brought to bear upon the Jews of Germany during the period of National Socialism. Even though some German people had rejected National Socialism, Adenauer would concede that unspeakable crimes had been perpetrated in the name of the German people. And that fact alone imposed upon Germany, the state, and Germans, the people, the obligation to make moral and material amends as regards the individual and collective damage suffered by Jewish people. As a result, Adenauer proclaimed restitution legislation would be brought into operation. Jewish property would be returned. The government of Germany was prepared to bring about a solution to the material, let's emphasize, to the material reparation problem in order to facilitate a way of spiritual purging of the suffering of a past epoch. And Germany was fully convinced that the spirit of clear humanity must once more become alive and bear fruit. Thus, Germany and the Germans accepted the moral responsibility for the crimes committed, not by themselves individually, but in their name, in the name of National Socialism. This acceptance was soon translated into a legal obligation. We see this in the Conference on Jewish Material Claims Against Germany, established in New York of 1951, in which a claim of 1.5 billion US dollars for the restitution of the Jewish victims of Nazi persecution was passed. It was passed even though it was recognized that financial payments could not make good the destruction of human life and cultural values, and could not atone for the agony of the men, women, and children tortured or put to death by a very inhuman device. Restitution, however, remained a non-negotiable, as we can see from the two Luxembourg protocols passed on the 10th of September, 1952. What was covered by these protocols? Deprivation of liberty by reason of persecution, compulsory labor, deprivation of decent living conditions, deprivation of property, deprivation by death of family relatives. So these Luxembourg protocols were a watershed moment in international relations. No state had previously accepted moral, financial, and legal accountability for crimes against humanity perpetuated by its leaders and its government. In at least two African states, there was hard evidence of crimes against humanity. The first was in the Belgian Congo, where Belgium, under the obnoxious ruler, Leopold, was responsible for the genocide of more than 10 million Congolese between 1885 and 1908. Closer to home in Namibia, Germany's genocide killing of the Nama and the Herero between 1904 and 1905 had long been described as a crime against humanity. Yet neither Germany nor Belgium have been prepared to confront the fact that the roots of the crimes against humanity run deep in their history, and that the first crimes against humanity were committed in Africa. I want to then return to why it matters that apartheid was a crime against humanity, and what lessons we can take from previous examples about restitutive policies pursuant to crimes against humanity. Apartheid was a crime of inhuman acts, rightly condemned because it denied and violated the humanity of its victims. The focus of the crime against humanity is not the race of the victims, but their humanity. But despite this, in this country, there have been no meaningful financial, material, moral, or in fact, legal reparations for the victims of apartheid. This is the problem I wish to interrogate further. We should locate apartheid in its moral, political, and historical context. Formal apartheid has been abolished. In fact, it was abolished prior to 1994. But social and economic apartheid continue to thrive. The World Bank recently delivered a brutal and a frank assessment of the enduring scars of apartheid to the economic order. In 2018, race, geography, and gender, according to the World Bank, remain the key indicators of wealth, precisely the way apartheid was designed. I want to suggest that the forced dispossession of the land held by Black people in South Africa was the act that most decisively deprived Black South Africans of their means to resist being reduced into a laboring subclass under apartheid. It is at once the most visible symbol of apartheid colonialism. The restoration of land, material reparations, restitution of property is therefore an imperative of justice and a necessary measure in the ongoing struggle for the reparations for the crime of apartheid. Expropriation of land was identified by the United Nations as a key element to the crime of apartheid. And why was this so? It recognized not only the crime comprising the dispossession of land, but also its connection to race and racial subordination. This political entity, known as South Africa, only came into existence in 1910. Rights of citizenship were denied to African people, or they were called at the time natives. In fact, we know this explicitly from Section 35 of that act that defined eligibility for franchise, which expressly excluded native people and reserved rights of franchise to European adult males. We also know this by the languages that were recognized, Dutch and English. We also know from the qualification of political office, which was reserved for those who had resided in the Union of South Africa, and those who were British subjects of European descent. So when apartheid is installed as the official political ideology in 1948, the precise intention is to turn it in law into a white man's country. And thus, racial conquest now assumes a legal force. But as a matter of social structure, political structure, and economic structure, race and dispossession based on race had long been part of the fabric of South Africa. To give effect to the 1910 South African policy, the Native Land Act of 1913 was passed. It included a schedule of native areas, which listed existing reserves, locations, and farms for occupations by Africans, which constituted 7% of the total surface area. Section 1 expressly forbade natives from entering into any agreements for the purchase, hire, or acquisition of land from any person other than a native, except with the permission of the Governor General. But we know for a fact that that permission was hardly ever granted. Any breach of the act would result in a crime, punishable with a fine or imprisonment of up to 6 months. Many people are under the impression that it is the Native Land Act that deprived Africans of their land. But Richard Msimang, an attorney whose life story I have written about elsewhere, has considered it a mistake to confine our understanding of the impact of the Native Land Act to loss of land. For Msimang, the true effect of the Native Land Act was the loss of security of tenure, loss of property, particularly in the form of cattle. The stories that he recorded illustrated that these cattle and these farming implements were in fact not lost. They were confiscated by white farmers. Often sham transactions were entered into, in terms of which blacks were tricked to sell their cattle or had their cattle sold in order to have a place to stay. But he also noted that that act had the effect of converting overnight scores of black people into a class of laborers. And the stories of Natal and Orange Free State illustrated that these were no ordinary laborers. They were unpaid laborers, akin to forced laborers. And the laws that followed since then only served to entrench the subservient position of Africans. And it was these acts, the racialized dispossession of cattle, the turning of independent property holders into wage laborers, and the ultimate act of marginalization, discarding, that moved the international community finally to declare that apartheid dispossession was a crime against humanity. And apartheid, let us emphasize, was not a system merely of racial categorization. It was the edifice built from black labor, black dispossession, and the exploitation of black bodies. And so by 1985, 12 years after the resolution of the United Nations, which condemned apartheid as a crime, this country expected P.W. Botha to cross the Rubicon, but he would not. He would insist in Parliament that apartheid would remain. He would insist that Nelson Mandela's already lengthy tenure of incarceration would be extended. But that was all in the political plane. The Convention Against Apartheid of 1973 recognized the economic foundation of apartheid. So as Botha was bellowing with indignation in Parliament, the military tanks, the armored vehicles, and the police Caspers were driving into black townships, engulfing these townships into a thicket of smoke from their tear gas canisters. But who was financing them? They were oiled and fueled by the large petroleum companies of the world, Shell, BP, and Mobil. Collectively, these companies controlled more than 80% of South Africa's market for petroleum products. It is often said that white-owned local and international companies made super profits during the years 1960 and 1980. But less spoken about is that this was the result of the apartheid policy of oppressed and extractive labor. 3 examples illustrate the symbiotic relationship between the white apartheid administration and white businesses, precisely the very point of the convention. First, the past laws to control migrant workers. The past laws have a checkered history in South Africa. Although their ostensible justification was the maintenance of the register of native people, their real effect was the control of labor for the benefit of white business. According to the report of the Truth and Reconciliation Commission, migration control regulations were first drafted by the Chamber of Mines in 1895 as a response to the state's reluctance to organize a stable and constant supply of native labor. And therefore, the intention of migration control was to have a hold on the native whom we have brought to the mines. And so the pass system, which was at the heart of the Sharpeville massacre today in 1960, was primarily an economic instrument. The second example is the Masters and Servants Act. This act made it a criminal offense punishable by imprisonment for Black workers to break their contracts of employment by desertion, insubordination, or refusing to carry out the command of an employer. In other words, the employment relationship was policed on behalf of the large employers of South Africa by the state. And the Native Labor Act prohibited Africans from joining trade unions. And the establishment of trade unions was itself a criminal offense, again proving that at the heart of apartheid lied the idea of economic and political exploitation. And then another third element of apartheid, influx control regulations. Many people assume these regulations are based on racial hatred. They were justified on the grounds of their compatibility with the policy of separate development. But these influx control regulations served the important commercial goal of turning Black labor from the cities to the farms. The design of the legal order thus enabled apartheid capitalism to thrive. So when the international community declared the system or the systematic dispossession and racialized forced labor as crimes against humanity, the class of persons who were responsible for the commission of the crime transcended the state. Businesses who were complicit with the apartheid government also fell within the net of criminal responsibility. A declaration of criminal conduct, however, would not deter business. positive action was necessary. Economic boycott and sanctions against the apartheid state were adopted by many countries. But as we know, many companies based the economic sanctions. So the findings of the Truth and Reconciliation Commission on the complicity of business in apartheid were unequivocal. Even as it failed to single out individual corporations, it was at the very least able to conclude, quote, business was central to the economy that sustained the South African state during the apartheid years. Certain businesses, especially the mining industry, were involved in helping to design and implement apartheid policies. Other businesses benefited from cooperating with the security structures of the former state. Most businesses benefited from operating in a racially structured context. Although sanctions were imposed against South Africa by the international community, the reality on the ground was that the machinery of the apartheid system just kept grinding on. For corporates, breaking the sanctions meant more profits, and the promise of higher profits outweighed any desire to play their role in the freedom of Black South Africans. And indeed, for oil companies, their loyalty to apartheid was rewarded in 1985 when Chris Jonas, a member of the National Party in cabinet, announced the Equalization Fund in which BP, Shell, and Mobil would be paid at more than the prevailing market rate for providing fuel to the police and military vehicles of South Africa. In their cooperation and codependence with the apartheid state, the oil companies were not out of step with their domestic counterparts. The same applies to Anglo-American. If one looks at the report of the Truth and Reconciliation Commission, it holds that Anglo-American held a 20% holding in Barloworld. Barloworld, in turn, was a major producer of defense electronics consumed primarily by the state. As a subsidiary, Barloworld paid dividends to Anglo-American. 3 members of the Barloworld board executives, including the chairman, were members of the Defense Advisory Board of the then President P.W. Botha. Anglo-American chairman Gavin Raleigh served on the Armscor board, the apartheid government's arms manufacturer. Armscor board comprised no less than 13 prominent businessmen, including the chairman of Anglo-American, Gavin Raleigh, and the representatives of Barloworld. But when apartheid had become internationally unpalatable, because, among others, of the 1973 convention, the anxieties of business were not to obliterate it as such, but to save it in different guises. Take, for instance, Gavin Raleigh's statement, who rejected the idea of one man, one vote at this point in time in our history. Or take Anton Rupert of Rembrandt, who pronounced in 1981 that after many African countries became free, they got dictators like Idi Amin. We have to find a solution that won't end up giving us one man, one vote. Similarly, Harry Oppenheimer was not in support of the ANC style of one man, one vote. Most of this ultimately fell away, but big business remained influential during the transition, including beyond the transition, negotiating a place for themselves in the transition and in the post-transition world. The negotiations that took place after the release of Nelson Mandela in 1990 produced the Truth and Reconciliation Commission, which would serve as a platform for truth, amnesty, and reconciliation. But with apartheid having been a crime against humanity, which benefited, as I have shown, big business, and in fact, which was sustained by big business, who would take responsibility for apartheid? Would we give effect to the explicit terms of the 1973 convention? In the book Country of My Skull by Angie Kroch, she described the first day into the hearing on the role of business under apartheid on the 11th of November, 1997, before the TRC. There was a touch of surrealism, she says. The wealthy captains of industry, Nicky Oppenheimer, Bobby Godsell, Julian Ogilvie Thompson, were all dressed in designer suits, and they sat opposite the commissioners to be questioned, just as hundreds of others have sat before them. An illusion, at the very least, of equality was created. Not even the rich were above the law. And yet, that illusion quickly dissipated. In the first of the 3 days, business representatives would begin not on a note of admission, but on a note of denial, pleading innocence and then pleading ignorance. Take Johann Rupert, who, according to Kroch, led the denials. Rembrandt, he said, was started by Afrikaners and sustained by Afrikaners long before the Afrikaner had financial clout. Rupert would protest. By the third day, it had dawned upon the captains of industry that their pleas of innocence were bad for business. But they would produce no facts. They would tell very little truth. Their pleas for forgiveness would come in abundance. Forgive us for Steve Biko was one of the extraordinary statements made by Johann Rupert. When those hearings finished, many promises were made to set things right. But as Angie Kroch observes, these promises to set things right were made only to look good on the 8 o'clock news. After the hearings, it was pretty much business as usual. The oil companies who were responsible for putting petrol into the apartheid military vehicles simply did not even show up at the TRC. Those who showed up simply shelved their submissions and carried on with their lives, as they had done before. The report of the TRC did not explain why it did not take more drastic action against big business, merely noting its regret. The same applied to land. No thoroughgoing examination was made by the TRC about property dispossession and the expropriation of land. And yet, this was a central element of the 1973 convention, which described apartheid as a crime against humanity. It seemed that the TRC had forgotten the primary essence of apartheid, and it was investigating crimes under apartheid and not considering apartheid as itself a crime, a systematic crime that could only be sustained by the exploitation of Blacks, but a crime that had beneficiaries, which is the white society as a whole and white businesses in particular. This is why Sampie Blanche, himself formerly a supporter of apartheid, but by 1997 had rejected apartheid, explained that in order to overcome the true impact of apartheid, the new South African government had to focus on the systematic nature of apartheid by considering, first, the deprivation of land, secondly, the fact that millions of Africans were paid exploitative wages in the gold and agricultural sectors. Thirdly, the fact that Bantu education had made it impossible for Africans to acquire skills that were necessary to enable them to operate in the modern economy. Fourthly, the fact that the prevailing socioeconomic power structures made it impossible for Africans to accumulate human capital. There was uneven and grossly unequal government spending on education, health, and housing, which effectively created two worlds in one country. Fifthly, the restrictions put on the right to acquire property and the right to conduct business, which had the combined effect of depriving Africans their ability to accumulate and build wealth independently of state assistance. Sixthly, the fact that it was not only individuals that were impoverished by the system of racialized capitalism, but African society as a whole. The needs of labor often meant the breaking up of families. Sometimes breadwinners were killed in the acts of repression by the police. Take the mass killing of Sharpeville in 1960 and the trauma that it set upon the families and the national trauma that it set upon Black society as a whole. Or take the mass killings in Soweto of 1976, both the generational and intergenerational trauma that it spawned. Or take the mass killings of Langa in 1985. They did not only leave hundreds of Black bodies dead, but they also left highly traumatized societies where the trauma was passed from generation to generation. As in any traumatized nation, the trauma is passed and distributed internally, leaving broken people and broken societies. And it was in this context that Terblanche explicitly proposed a form of taxation to be paid basically by whites for the benefit of Blacks. And this is precisely what was at the heart of Adenauer's proposal about how to deal with material reparations owed to Jewish people as a result of the Nazi exploitative era. And this was precisely what was at the heart of the 1973 Convention on Apartheid. It's material reparations leading to spiritual reparations. But these proposals were opposed and the idea was discredited before it could take root. A similar recommendation by the Truth and Reconciliation Commission was also not accepted by the ANC government. Instead, paltry sums of 30,000 rands per family were deemed appropriate in respect of those individuals that qualified for reparations. And that definition of reparations was itself a narrow definition based on the idea of a gross human rights violation, which itself began only from March 1960, signaling Sharpeville. But businesses largely got away scot-free, and so did landowners. Not only did they retain the land, they retained the benefits accumulated over the land. Most still had farm workers, Black farm workers, whose conditions had hardly changed. Land, in any event, as a subject, was excluded from the terms of reference of the TRC. Instead, a different dispensation, which has produced no results, was agreed upon. As we conclude, let us note that the exclusion of the economic question from the TRC and indeed from the structure of the Constitution meant that one of the goals of the 1973 Convention, which was the material restoration as a consequence of a national exploitative system, was not addressed. And by excluding land, the restitutive goals of the TRC simply failed to address the original sin. Let us again recall some of the elements of the systematic crime of apartheid. Systematic dispossession of the land, displacement of persons on account of their race, the creation of conditions akin to forced labor, the establishment of reserves and ghettos, the oppression of one race by another, the creation of a legal system which makes it lawful to perpetuate a system of oppression. The institutionalization of that legal system by establishing state organs to oversee the system. These are all the elements of the 1973 Convention of the Crime Against Apartheid, or the crime of apartheid. The perpetrators of the crime against humanity, which was the Holocaust, faced their comeuppance at Nuremberg. Germany, the state, accepted moral and political responsibility for the suffering. Businesses that benefited from the exploitation and the murder of Jewish people contributed their share to the reconstruction of the Jewish society. Of course, there is no point in comparing the suffering of one people with another. Yes, both the German Holocaust and South African apartheid were declared as crimes against humanity. But that does not mean that they were the same crime against humanity. But the point to be made is not the comparison of suffering, but it is to ask the question of the possibility of reconstructing of a society without material reparations. South Africa's crime against humanity, which is apartheid, apparently had no criminals, no beneficiaries, only victims. F.W. de Klerk, leader of the National Party during the TRC hearing, would only accept collective responsibility for apartheid. Volume 5 at page 225 of the TRC report remains blacked out in the section intended to address de Klerk's alleged culpability for gross violations of human rights. The killings of today in 1960 Sharpeville, Soweto, and the state of 1985 emergency remain largely unaccounted for. Primary beneficiaries of forced and cheap labor, who were the English and Afrikaner businessmen, took no responsibility for benefiting from a system of racialized capitalism. Many would not even honor the invitation to account publicly before the TRC. Perhaps, as Sampie Blanche points out, we are probably lost in transformation. Given the continuing facts of racialized capitalism and the unfinished business of the TRC, and quite frankly, our inability to get closer to the 1973 convention, we can ask ourselves the question, is apartheid a forgotten crime against humanity? Thank you.
Wow. How do we clap virtually? I do not know. This has been an outstanding lecture. Thank you very much. I see Awonke is showing us the way. Thank you very much, Advocate Tembegang. I mean, as I said, you can count on him. I mean, if you request him to do something, he delivers. Colleagues, this is, just to remind you, this is a joint event organized by the South African Commission, National Commission of UNESCO, the Department of Social Development, as well as the Johannesburg Institute for Advanced Study here at the University of Johannesburg. Advocate, when we discussed, we'll have perhaps about 30 minutes or so. If people have questions or comments, the floor is open. You just indicate if you want to comment or ask a question. Any questions or comments? Yes, Eugene, let's start with you.
Thank you very much. Let me agree with you. It is indeed palatable. Advocate never disappoints. We really appreciate him, and we appreciate you for ensuring that you convince this important discussion. I want to pose a question to the advocate. because he have already identified and clearly stated that in terms of the apartheid incidents, the manner in which they did things, in terms of our knowledge, and today, in terms of facts, no one have been prosecuted. We got only victims. No one have been prosecuted, and no one have been identified as the perpetrator or the one who orchestrated apartheid and ensured people have lost their lives, number one. Number two, their land, and displaced. I'm trying to confine myself to what he said. But in terms of the law, we can open inquest, we can follow up. How do we do that in this day and age? Because we cannot let those who have treated us badly, and like he said, these were labeled as crimes against humanity. But in Germany, Hitler and his team were prosecuted. So how do we deal with that? How do we ensure that this doesn't happen anymore, and those who have done this are held accountable? I'll pause there. Thank you very much.
Advocate, please go ahead.
Yeah, thank you. Yes, I mean, I think that's a very vital question. I mean, I think the 2 points I was trying to make, I mean, firstly, so as far as the crimes of apartheid are concerned, in other words, the specific acts of a policeman, killing people, whether it is the COSAS 5 or the PEPCO 3 or the CRADOC 4. So you've got a particular group of policemen, they have planned and they have executed a killing. And maybe that was because, that was the design of the system, that they should be murdered. The problem we've had is the Truth and Reconciliation Commission obviously did not find anyone guilty. That was not the intention. It was unlike the Nuremberg trial, which was intended to put someone on trial and find them guilty, which is what happened in Germany. So here what we had this idea that we can reconstruct the society through a system of truth-telling followed by forgiveness, and then hopefully followed by reconciliation. So you tell the truth, you get amnesty, and hopefully we will reconcile, and the reconciliation will be based on the truth. But what we know for sure is that many people lied at the TRC. Others did not even go to the TRC. But the problem is that even those who lied, even those who didn't go, in other words, people that did not get amnesty, have not been prosecuted. And the obligation to prosecute them was the obligation of the ANC government that took over. We know from the testimony on oath of Advocate Vusi Pikoli, who was the head of the NPA, that he blamed the executive, Bridget Mabandla, and former President Thabo Mbeki for interfering with the NPA in relation to the prosecution, the decision to prosecute. So you find that in a judgment called Rodriguez versus NPA, which is a judgment of the Supreme Court of Appeal. So it was clear, according to Vusi Pikoli, political interference, which meant that the prosecutions couldn't take place. Of course, we've got to work on that. I saw recently that the NPA says it's now resuscitated the Special Prosecutions Unit, and that it will go back and prosecute. But we are dealing with 29 years. Evidence is lost, people are dead. The killers of Steve Biko, killers of Chris Hani, one of them recently got amnesty. The killers of the CRADOC 4 have not, been prosecuted. So that we need to put in pressure on the NPA to prosecute the criminals that have not been prosecuted. So I think that's quite clear in relation to the individual acts of criminality committed in support of the apartheid system. But my point in the talk was to expose the systematic nature of apartheid and to say that the power of the 1973 declaration is not to look at apartheid through singular acts of its functionaries, but to look at apartheid as a system. And then to ask the question that if we understand apartheid to be a system, what is the correct response to it? In other words, is the TRC model, which is the only model we have that actually confronts the problem of apartheid, was that TRC model an appropriate model because of its failure to address the entire system as a crime and its focus on specified acts of criminality under apartheid? So that's the big challenge for taking society forward. And that's why I pose one of the questions drawn from the example of Adenauer, the question of material reparations. In fact, is it actually possible to reconstruct a society after 350 years of racialized exploitation and formally racialized capitalism? Is it possible to expect African people to basically lift themselves up with their own bootstraps without a system of material reparations? That's the question I am exploring. And I'm afraid I think that it's not possible to reconstruct society without a system of material reparations. I think that the burdens that we have imposed on the state are impossible burdens if the true beneficiaries of the apartheid system have not come to the party.
Thank you. I'll take two questions, Tana as well as Zwelithini. Let me start with you, Tana.
Thank you. I have two questions. The first one is, as far as I know, the South Africa itself is not a party to the 1973 convention. And so I was just wondering whether that precludes actually being able to use the convention to push for reparations. And then the second question is, you said that in Article 5 of the convention, persons who are charged under this convention need to be tried by a competent tribunal. So what do you think for me, the word competency needs to be unpacked. Like, what does a competent tribunal in this case actually look like? What would be the characteristics that one would need to actually imagine in terms of designing such a process? Thanks.
Before you answer, Advocate, let me come to you, Zwelithini, your question.
Thank you. My question is very short. I understand that the evidence might have been lost. It might be 20 years ago for TRC, but the businesses that benefited during apartheid time, we still have them, and they still find it easy in the current government to make profits and to continue as if nothing wrong happened. They never funded the apartheid, which was declared as a crime against humanity. Even still today, they are calling the shots. They are still big businesses. They are not even affected. And what is your view, Advocate, on that? If we can trace such big businesses and such big businessmen like the likes of Abu Rupert, if they are still there, can we still engage them? Because we still have an evidence that they benefited at our expense, at them exploiting us, and it's still affecting us. They can't say it's very late and time it's against us, but they are still finding it busy to an extent that some of them, they are co-opting our leaders, the current leaders. They've got shares in such big businesses, which made life difficult during apartheid. And what is your view around that? Thanks.
Advocate.
Yeah, thank you. I mean, I think on Tana's point, I mean, it's true that, we are not a party to, South Africa as a country is not a party to the convention. It could not be a party because it rejected the convention. I think the US and the UK, but one of its partners, or even France for that matter, refused to sign the convention. But it's still a convention in international law, which meant that South Africa could be held culpable internationally. It could be taken to the ICC, they could be taken to any of these forums, for anyone who has committed the crimes of apartheid. But in any event, the crime of apartheid itself is domesticated in the Rome Convention, which South Africa has a Rome Statute. So anyone responsible for crimes of apartheid that are now, defined, it's possible to prosecute them domestically in South Africa. But none of this really moves the debate forward, because South Africa adopted the National Reconciliation Act, which was the basis for the establishment of the TRC. And so the problem was that there was a narrow definition of violations of human rights, gross violations of human rights. And that narrow definition basically ultimately meant that we were dealing with isolated acts, basically perverted acts of certain individuals. And we were not looking at the institutionalization of the system of racism, which is what apartheid was about. And that's why there's the power in that convention. So that convention still serves as a very useful moral and legal framework, even if not materially binding, but still serves as because it opens our eyes to understanding the systematic nature of apartheid, and not looking at apartheid as, white people hated black people, but to understand that it's a system of racialized capitalism. And if you are serious about overcoming the system of racialized capitalism, you have to confront it at root, of course, to focus on the systematic nature. Most of this work obviously can be done in competent tribunals, whether it's domestic or international tribunals, but a lot of it is political work. And it's the political work that has been postponed. And unfortunately, as this is the point of citing the World Bank report, these are inequalities that we've inherited from apartheid, but they are inevitable inequalities because we have not confronted the systematic nature of apartheid. And in fact, what we are doing, and that's one of the points I made in the paper, is that the gap between the aspirations of the convention and the lived reality of Black South Africans is widening instead of closing. And then for Zoliti, I agree with everything you have said. I agree. We know these businesses that benefited under apartheid. There has been a betrayal by the government, because when there was litigation, not in domestic courts, but in international courts in America and elsewhere, when there was litigation for reparations against these businesses, the South African government signed an affidavit in support of the dismissal of the claim. It's cited in a US judgment, in a footnote signed by the former Minister of Justice, Penuel Maduna, who said that there was no need for international forums in the US to give an order on reparations in relation to companies that aided and abetted apartheid, because we had the TRC model, right? And that's quoted in the US judgment in dismissal of the claim for reparations, that because of the TRC model, there was no point in getting the international and local businesses that aided and abetted apartheid to pay reparations. So politically, that fight, the ANC has, well, not the ANC as a party, but the ANC government has certainly been opposed to it. But 50 years later, we have to really reconsider what the position of South Africa ought to be in relation to businesses that aided and supported. And I try to problematize the role of business, because they were central to the PW Botha administration. They formed part of his advisors during the time of, I think he called it the total strategy, during the total strategy, when he was under siege, feeling that global communism, would take over South Africa. During that period, when you look at where did he resort to, he had, basically businesses supporting him. Now, during the transition, they were very adept at previously supporting the apartheid government, and then during the transition, supporting the ANC government. So playing both sides, and then also trying to shape the transition itself, because that's also a crucial role that they play, trying to shape the transition. So if you look at statements made by the Anton Rupert's, the Gavin Rileys, the Zach de Beers, etc., they were also trying to shape the transition, for their benefit, not for the benefit of the many. So we now are sitting in 50 years after the convention, and the convention makes very potent statements about what was the role of big business during apartheid? The question for us is, do we also turn a blind eye on the complicity of business with apartheid that continues to exploit and continues to benefit? Or do we, in fact, take some form of action? One of the ways of doing that is precisely this conversation, that we've got to shine the spotlight on business accountability for the continuation of apartheid.
Thank you. Any questions? Perhaps while we are waiting for more questions, okay, just two questions from me. Firstly, it's about the German comparison. I do not know whether you can talk a bit about that. Because I don't know, perhaps whether it was easier for the German government or not. I mean, partly because you had a state, I mean, in a sense that had been established, I mean, Israel, perhaps transferring resources, I mean, to those groupings was relatively easy. I don't know whether you can just elaborate a bit, I mean, about the differences between the South African case and the German Jewish case. I mean, that would be the first question. I mean, secondly, perhaps to explore deeper the explanations or the arguments of the South African government for not, in a sense, following the lead, I mean, that is contained in the Apartheid Convention, because the argument against reparations was that there was a program of government, I mean, that will deal with the legacy of apartheid, and that perhaps it was not necessary to follow the German situation. I do not know whether you can reflect a bit on that argument. I mean, made in that case in the United States, but also made against reparations. I mean, because there was a push for reparations in South Africa, and the South African government was against that. I mean, it said it is the responsibility of government to deal with that issue. I mean, I'm just letting those issues for your comment, but can I take Pedro to raise his own?
Thank you, Dr. Mulunga. Just two quick questions, Advocate Ngwatobi. It's Pedro here from University of Free State in Bloemfontein. Firstly, when you say that apartheid was not necessarily a system of hatred of Black people by white people, what exactly do you mean? Because I don't think there's any way that we can systematically push a people into a corner of violation and stripping of their humanity to that extent, unless you driven by hate about such people. Because, I mean, Fanon says this as well, that the very essence and the existence of white people as white is the fact that there is a native, a Black native next to them that they are oppressing. So the native, in essence, is a creation of white people. It's a creation of white colonial domination in essence. So that's the first question. Question two, with the available evidence now that we have, I mean, there are reports from the World Bank. We could, pull up so much data to show how white people benefited from apartheid, even up to this point, including the physical evidence from companies, as what was tabled by the previous question. Is it possible, therefore, that if maybe, let's say, next year we change governments and put in place a different one now that will proceed with the prosecution of white people for these crimes, would that essentially be done if that switch of governments could be instituted, let's say maybe in the following year, and then a government now that has appetite to proceed with these apartheid crimes takes over? Just those two questions on my side. Thanks, Chair.
Okay, thank you very much. Before you answer, Advocate, I just want to say this, the lecture as well as these conversations, I mean, they are being recorded. And so they will be on YouTube, the YouTube channel. And if you check the chat there is a link. So please go ahead then.
Yeah, thank you. I think just to explore the points you were making, Dr. Mulu, I think the first one on the German comparison. I mean, in the longer paper, I'll give you the longer paper, but I was presenting here the shorter version. In the longer paper, I do try and see what made, you know, the German situation in relation to reparations. Why did that succeed? So I find that there were three fundamental elements to it. One is, as you point out, the nascent Jewish state. I think it was Ben-Gurion, who was the prime minister or the president of Israel at the time, who actually pushed the movement for reparations. The second, remember that after the Luxembourg protocols, you know, because there was, I think, $1.5 billion set aside by businesses in the Luxembourg protocols. That money ran out, you know, They finished that money. And then there was reluctance to payment. It was, yeah, it's Ben-Gurion who pushed for the reparations. So that money was actually finished. They spent it, etc. But in 1997, Jews themselves and their organizations instituted a class action lawsuit in the United States District Court in New York against insurance companies, for instance, where they sought the recovery of Holocaust-era insurance policies. So if you insured Mercedes-Benz, which you knew that they were primarily responsible to aid and abet Hitler's government, they sued them. And they also sued for slave labor. Credit Suisse, for instance, and UBS, the banks, they paid 1.5 billion. Volkswagen contributed. The District Court of New York allocated another 1.5 billion, and several Swiss banks. And then that was 1997. There were new claims brought in the US, you know, in 1997, and a lot of money was paid as a result of that class action. And then in 2016, most recently, the German government decided that it would provide home care funding for Holocaust victims up until 2018. So for that, there was a lot of money. Again, it was 282 million euros, 315 million euros, 350 million euros. So 282 for 2016, 315 for 2017, 350 for 2018. And then it also fundamentally transformed the classes of victims, because, you know, if you started in 1951 at the time of the Luxembourg protocols, it's the immediate victims. But as the time passes, you know, the victims die, and then there are new people coming in. The class fundamentally transforms. So it's now great-grandchildren, you know, that benefit under these schemes that are introduced. So one is Ben-Gurion, is the role that he played, and then secondly, it's the power of the legal system. You know, once they instituted those class actions, you know, it just triggered a set of other reparations. And of course, you could say there's something about the German government, because at the beginning, Adenauer himself had made this commitment that he will be looking into it. And then even later, when the money had run out, you know, the German government then, you know, made undertakings in 2016. So if you think about the fact that, I mean, the last reparations we're dealing with for the German Holocaust are 2018 reparations, and the German Holocaust, you know, is around 1939, maybe to 1945. So we're dealing with an event that is approximately 80 years old, but reparations are still being paid. Whereas when you are dealing with apartheid, apartheid a fairly new thing, and there's just no movement whatsoever. So I do think that maybe those three elements, provide a distinction. So firstly, the fact that we couldn't effectively use a legal system here. Secondly, we had a government that was opposed to reparations. And then thirdly, you had private capital that was also not interested in the payment of reparations. And then about interrogating the explanations of the South African government, I just find them unconvincing and inexcusable. I can understand the argument that says you should not burden the South African government with the obligation to pay reparations, because the South African government is a new government that cannot take responsibility for what happened under apartheid. I understand that, but I think it's not a valid argument because of the principle of legal succession. And Adenauer in Germany had in fact accepted both moral and legal responsibility, that even though some Germans were opposed to National Socialism, the fact is that National Socialism was practiced in the name of the German people. That's a very, very powerful thing, in the name of the German people. And I transpose this to the South African context, that apartheid was practiced in the name, in the name of white people in South Africa. And that's why I think meaning seriously about an extended and widened system. And that's the power, I think, of this 1973 protocol, to say, well, it's not just businesses, but it's white society as a whole, because the system of apartheid is created for their benefit. And in fact, materially, it's them who benefit from the system through the exploitation of Black labor. So I don't think that the arguments of the South African government are valid. And what's worse about them is, when they put in an affidavit before the US, that was not an affidavit to protect them as the state from paying. It was an affidavit to protect corporations from paying reparations. Now, that just makes no sense. Why would the South African government protect corporations that aided and abetted apartheid from paying reparations to victims? I don't understand why they thought they should interpose themselves. So firstly, on the argument that they as a government should not pay, I think that's an invalid argument as exposed by Adenauer. And secondly, I don't see the point of them interposing themselves between victims and capitalists, really. I think they should have left that fight to other people. Pedro, I think we misunderstood each other, because I've gone back to the actual line. I wanted to just read that line. I think you misunderstood, or I missaid it. I don't know where the misunderstanding is. But I could never say that white people do not hate Black people. I mean, it's clear that they did. What I think, I just want to go back to that line to see precisely what I said. Yes, so I said the convention thus captured the essence of apartheid in three respects. It shifted the locus of accountability from the individual to the state. It recognized, and that's the point I think where there's misunderstanding, it recognized that apartheid was, by its nature, a systematic crime. And then I said, not isolated acts of individuals driven by racial hatred. And as a systematic crime, culpability for apartheid extended to all those who derived a benefit or advantage, including an economic advantage from the system. So I don't mean that, I mean that if you define apartheid as isolated acts driven by racial hatred, you are not going to define it in its full extent. But that does not mean that the system is not designed by people who hate Black people. I mean, Verwoerd hated Black people, that much is clear. Malan hated Black people, that much is clear. But that hatred is only part of the understanding of apartheid. You have to understand its systematic nature, including the political, the cultural, and the economic facets to it. So that's what I was saying. I was not saying that whites did not hate Blacks. I mean, that would be wrong. If we changed the government, could we sue? Yes, I mean, I think we could. I think if you look in Namibia, there was litigation now recently for reparations against the German government. It was instituted in the US courts. And so you still have all of these corporations and entities that are operating in the US courts. And if you think about the Namibian Holocaust is 1904 to 1906. And that litigation was about 3 years ago in the US. And there was a settlement of something like 2 or 3 billion euros. And there's a big debate in Namibia about whether that's sufficient or they need more money, etc. But I think that the movement to push for reparations has to continue. One of the complications of South Africa is that most of the beneficiaries of apartheid are domestic capital, and a lot of their wealth is no longer sitting in sort of private hands, quote unquote, but it's been, some of it has been acquired by the pension funds. And so, for instance, if you look at a company like Anglo, I mean, I don't know the shareholding of Anglo, but it's one of the prime examples. Look at a company like Anglo, you will find that maybe 15% and maybe 20% is now owned by the PIC, and because the PIC is heavily invested in all sectors of the economy. So that's what creates complication. But I don't think it creates legal complications, because you take over a company, you are responsible for its previous deeds or misdeeds. So you sue the current entity for the acts of the previous directors, because even within company law, there is the principle of legal succession. So I don't think there are many legal reasons why these claims cannot be pursued. But I think what I was trying to say is that if you left most of this work to the law, I think you are still going to come up short. Most of this work has to be driven primarily by politics. And I think the problem we have is that we've had an ANC government that's primarily been opposed to any form of reparations talk, any form. It only wanted the package of reparations through the TRC, which was 30,000 for every family for the acts of apartheid as defined under the TRC Act. But wide-scale systematic reparations for the reconstruction of Black society, they've been opposed to them. And so my point is to use this convention as a springboard for the wider conversation about, should we not be revisiting the possibility of reconstructing Black society oppressed over 350 years and exploited through a reparations movement?
Thank you. We are supposed to end in about 2 minutes at 5:30. I mean, there is a question about the title of your paper, because we want to access it online. I don't know whether you can just give us some information about how people can access it, I mean, especially those who might want to use it. Maybe let's take Eugene before you come back. I mean, I see Eugene has a hand up, then you can answer that question and then give your concluding remarks. Eugene, I see you had your hand up.
Yeah, thank you very much. My question is not necessarily within the discussion. I want to smuggle something that is juicy and it's all over the media. And because we don't have an opportunity to interact with a guru like the advocate here, I want to understand his view about the ICC stance in terms of why they want to say Putin must be prosecuted while is not a member. Russia is not a member of the ICC, and they've been doing funny things all over the world. George Bush killed people in Iraq. Barack Obama killed Gaddafi. And even today, those economies cannot recover. So I want to understand what is the attitude of the advocate in terms of these developments. Thank you very much.
Thank you. Zolitini, I saw your hand up. If you can just say something quickly before the advocate.
No, sorry, I'm okay. I lowered it. Sorry.
Thank you. Back to you, advocate.
Yeah, thanks. Yeah, I mean, look, I don't agree with...
Sorry. Let's give Shwai a chance. I just want to, I see Shwai is just racist. Right.
Thank you, comrade. Advocate, what I'm trying to say is this is a very emotional thing. You know, there's this cartoon of the fat cats having a party or dinner. This top of the table is laid on the back of a lot of gas underneath, which in short is the Africans in terms of South Africa and the piece of a narrative that we have been sharing with us. The question is when can we start or how do we actually get into this thing physically to start the reparations? Because it raises all emotions. People will be saying, we told you, these people need to be driven back into the sea where they come from. We told you this and this. So when can we really start the Madunas, whatever they have signed, this reconciliation that we have gone as Africans far overboard? And then the poverty here is really grinding us. And the poor and the hungry are just about to stand up and stop this party, throw us all into the ditch, especially the African middle class. So throw all of us into the ditch, and then we pay for the sins, not of our forefathers, but of what we did, how we contributed to lack of reparation, to this foundational, systematic, economic and social sin. So can we read, how does one start? Do I go to a lawyer like you and say, I'm filing in a criminal case and a class case or something like that? Because it needs to be done. Otherwise, we are just on the brink of a civil war here. You see what is happening, this total shutdown, these are just simmering symptoms of something about to explode. So when we are here and then we are really dealing with information like this, what do we really need to step up and start practicing this reparation so that the poverty that is grinding the African nation can be minimized at least? Thank you.
Okay.
Yeah, I mean, okay, so Eugene. I mean, my own view. I mean, I don't agree with the structure of the ICC. I mean, I get the general point that it's necessary to have an international court for crimes against humanity and genocide. I get that point, but the problem is that they are very inconsistent with who do they charge for crimes like genocide. In America, I mean, you say Russia is not a party. America is also not a party. And so the decisions on who is charged are still probably heavily influenced by the interests of the West. I mean, there was a problem in Africa, by the way, not also Russia. But the problem in Africa, I think the first 7 cases, were all African leaders that were brought before the ICC, first 7. And the inconsistency has to be called out. Now, there's still the question as to what do you actually do for, especially if you have it's no longer a bipolar system. You've got a unipolar system that's concentrated along the West. Okay, maybe China is trying to introduce multipolarism. But what do you do if you have a unipolar system? How do you actually address systematic crimes? The one way is maybe they should establish a special tribunal. They did so in Rwanda, a special tribunal for dealing with war criminals, because you have to address war criminals, because you're not going to address them in a domestic court, because there's no way Putin is going to account in Russia, in the same way as George Bush is not going to account in the US. So the question is, people who perpetrate war crimes, where should they go? But I think that's more a political question which underpins the international legal system. And I do think that the international legal system is largely political, first and foremost. So I do not agree with the attempt at charging Putin by a structure as discredited as the ICC. But I think that there is a larger question about what system do we in fact establish in order to deal with international crimes, crimes that cannot be policed effectively domestically. So, which was the idea behind the establishment of the ICC. And by the way, Nelson Mandela, I think, is the first signatory, signed it in 1998, is the first signatory to the ICC, because I think he recognized the problem that if you've got war criminals, there is a place where they must account, but there is an ineffective system because of the demise of a bipolar world and the concentration of power in the West. Shwai, I'm with you. I mean, about this. If my point was really to, ask the question, because the title of the paper is is apartheid the forgotten crime against humanity? You know, it's to go back to that issue. The fundamental problem is that South Africa is yet to grapple with the consequences of apartheid. Now, that obviously is not intended to excuse the failures of the post-apartheid state, but it's simply to show how it has been a variant rather than a solution. It's simply been a variant to 350 years of exploitation of Black people. So what do we do now? I mean, there are things that can be done, I suppose. You know, people that committed acts of criminality under apartheid who have not been prosecuted, we can ask the NPA to prosecute them. If they don't, we can privately prosecute them, if that's the line we would like to follow. But we can also push a reparations movement. It really ought to be pushed. We've got to push a reparations movement. But I suspect that a reparations movement is ultimately political. But so what do we do as sort of people with platforms to public debate? I think it's just to make sure that the story of apartheid as a crime against humanity is never forgotten. You know, de Klerk denied that apartheid was a crime against humanity. He died before he could be prosecuted for his role in the killing of the Craddock Four. You know, and there are other people, other ministers that are implicated in the TRC report. They are also implicated in both of the inquest reports on the killing of the Craddock Four, but they have not been charged. So I think it's really raising the stakes to say, look, we must never forget that apartheid is a living crime against humanity. So if that is the thing I've achieved today, then maybe it is a worthwhile intellectual exercise.
Okay, so the title of the paper, there was a question there, okay, and how people can have access to it.
No, I'm going to send it to you. It's sort of a longish paper. It's 30 pages, but I've had to cut it to 12 for today's presentation. But I'll send it to you, and then you can. I don't know whether you put it on Dryas or what.
We'll circulate it for everyone who's participating here.
Okay.
And then we can circulate it to them. I mean, let me just say thank you. This has been amazing. I mean, it's a good way to start a discussion. I mean, as I said at the beginning, South Africa has been absent, I mean, in a sense, in these global debates, I mean, about reparations. I mean, last year there was a big thing in Latin America, and we were there perhaps, but not leading, I mean, these discussions. And this is a first start. And I think it has been an amazing start, and we'll have a series of these conversations about racism, about reparations, and I might come back knocking at your door, Advocate, for something else. I mean, especially during the course of this year, I mean, the 50th anniversary of the Apartheid Convention. But thank you very much, and thank you to all of you for participating and attending this wonderful discussion we have had today. I mean, as I said, it's a fascinating day for South Africans. I mean, it is Sharpeville, it is the Human Rights Day, and it is the International Day Against Racial Discrimination. And that is the reason why we thought we needed to do something. We'll do something similar next year, but we are also going to have a series of conversations during the course of this year, taking up on some of the points that have been raised in this conversation. Thank you very much.
Thank you.
Thank you. That brings us to the end of this. Thank you. I must thank my colleagues at the Department of Social Development, the guys at the Secretariat of UNESCO, and my colleagues here at JIAS. Thank you very much, colleagues.